So welcome back, dear students. Today we are going to cover up the third lecture from Unit 4 that deals with analysis of directive principles of state policy. And today we will learn the letter and spirit of Article 36 and 37 of Constitution of India. Dear students, by now we have learned that the directive principles of state policy are to be implemented by the state. Hence, the initial question is, who is a state or what is the definition of a state? Article 36 of our Constitution gives you the definition of state, and it says that in this part means part 4th, dealing with directive principles. In this part, unless the context otherwise requires, the state has the same meaning as in the part 3rd. In part 3rd, relating to fundamental rights, the word state was defined in Article 12. Please open up your Bare Acts and see what Article 12 says. Please always bring your Bare Act in the class. I'm reading Article 12 for your benefit. Article 12 says definition. In this part, unless the context otherwise requires, the state includes the government and Parliament of India and the government and the legislature of each of the states and all local or other authorities within the territory of India or under the control of Government of India. This is the definition of the word state given in Article 12. So this Article 36 enacts that the definition of the expression state in Article 12 shall apply throughout part 4th of Constitution of India, wherever that expression is used. Therefore, we have to see the definition of state from Article 12. Rather, we will have to borrow the definition of word state from Article 12. Now coming back to the definition of the state in Article 12, its relevance is that certain rights given by the state are given to individuals against one another, but fundamental rights are available against the state. Therefore, whether a constitution says it or not, it is generally presumed that fundamental rights are available against the state only, that is against the actions of the state and its officials, and thus the violation of right to property. Say, for example, somebody violates your right to property. Initially, it was a fundamental right. So violation of right to property by an individual is not within the purview of Article 12. State will not protect your property because state has not violated your right to property. Your neighbor, your relative, your friend, your brother, they have violated your right to property. So state is not at all concerned. So this violation of right to property by an individual is not within the purview of Article 12. Thus, whole object of part 3rd of Constitution of India is to provide protection for the freedom and rights mentioned therein against arbitrary invasion by the state. And hence, the definition of state was necessary. It was necessary to define the state because the protection of fundamental rights is available only against the state action. So according to Article 12, as I have read just before you, the state includes the government and Parliament of India. That means central government and Parliament. Parliament means Lok Sabha, Rajya Sabha, and the President of India. Second, state includes government and legislature of each of the state. Government means state government, and legislature of each of the state means Vidhan Sabha and Vidhan Parishad, Legislative Assembly and legislative council of each state. And third, state includes all local authorities. And number 4, other authorities within the territory of India or under the control of Government of India. Local authorities, you know, it includes municipalities, district boards, panchayats, etc. Whereas the first two category relating to central and state government, they include the legislative and executive wings of the union and state. Now, according to definition of state under Article 12, what are other authorities which are included in the definition of the state? It depends from case to case as decided by the Supreme Court as to whether a particular authority is included within the definition of state or not. And why this distinction is important, I'm emphasizing again that because some of the fundamental rights are expressly applicable to non-state action and some others are not expressly confined to state action. So fundamental rights may be violated by the state directly as well as indirectly. In the former case, its officials or agencies violate them, while in the latter case, it may let them violated by others through its inaction or active connivance. So the later violations may be as injurious as former one. So in such cases, state cannot escape its liability for the protection of fundamental rights on the ground that they are actions of the private individuals and not actions of the state. You see, we have a case, very important leading case, MC Mehta versus Union of India, commonly known as Shri Ram Oleum gas leak case. In this case, the Supreme Court granted relief to the petitioners against violation of Article 12 by a company, leaving the question open whether company was a state or not. Since this was a private company in Delhi, Shri Ram Oleum gas, and the oleum gas from this establishment leaked and caused injury to so many persons. So without going into the merits of the case, whether this Shri Ram Oleum gas company is a state or not, the petitioners were given relief, meaning thereby that indirectly the definition of state was enlarged by the Supreme Court. Then, dear students, we have another very important leading judgment, and we have read this judgment in earlier lectures also, that is Vishakha versus State of Rajasthan. In this case, a PIL was filed by a social worker for enforcement of fundamental rights under Article 14, 19 and 21 for gender equality. Supreme Court laid down the rules for controlling sexual harassment of women in all workplaces, whether run by the state or non-state organizations. See, I have highlighted this portion. Supreme Court covered the workplaces, whether they were run by the state government or by the non-state organization. If a workplace is organized by a private person or by a NGO, still the guidelines of Vishakha versus State of Rajasthan will apply to that organization, whether it is run by the state or it is run by non-state organization. And you know that later on Parliament enacted a legislation, and its name is the Sexual Harassment of Women at Workplace Prevention, Prohibition and Redressal Act 2013, which seeks to protect women from sexual harassment at their places of work. So point to be noted here is that this judgment of the Supreme Court granted relief against those organizations which are not run by the state. For the state, it is binding, no doubt. All the organizations run by the state are bound by this ruling. But even organizations which are not run by the state, they are non-state organizations, still they are being hauled up to follow these guidelines given in the mandamus petition of Vishakha. What is the impact of this judgment? That definition of state is indirectly enlarged by the Supreme Court, because non-state organizations are also covered and they are bound to follow these guidelines issued by the Supreme Court. Dear students, the application of fundamental rights may be studied in two ways. One is vertical application of fundamental rights. This means their application with reference to state only. And second category can be horizontal application of fundamental rights. It means that their application to fellow citizens or persons as much as to the state. So whenever we talk of vertical application of fundamental rights, that means their application with reference to state only we are talking. And when we talk about horizontal application of fundamental rights, that means that we are talking about their application to fellow citizens or persons as much as to the state. So dear students, we were understanding the definition of the term state under Article 12. And it specifies the authorities and instrumentalities functioning within or outside the territory of India, which shall be deemed to be state for the purposes of Part 3rd of Constitution of India. This definition of state in Article 12 is inclusive and not exhaustive. Thus, authorities are not mentioned in Article 12. They may also fall within the definition of the state, even if they are not mentioned in this definition. Now, what are other authorities? Other authorities means that this term state would include all authorities created by Constitution of India or statute on whom powers are conferred by law. And it is not necessary that the statutory authority should be engaged in performing government or sovereign functions. Now, there are several examples and leading judgments from the Supreme Court, like if I may ask you a question whether Rajasthan Electricity Board is a state or not. Suppose Rajasthan Electricity Board is not following the directive principles of state policy, or Rajasthan Electricity Board is violating your fundamental rights. Are they liable as a state? Yes. Yes, it was held in Electricity Board Rajasthan versus Mohanlal by the Supreme Court that yes, Rajasthan Electricity Board is a state. Then what about university? Whether university is a state? Suppose university violates your fundamental right to education and you are withheld from taking examination on account of your shortage in attendance. So whether university is a state? The original judgment from Madras High Court was that university is not a state and they are not included within the definition of state. But Allahabad High Court in 1968 in Umesh Chandra versus V.N. Singh decided that since the fundamental rights have been claimed against universities without raising the question whether they are state or not. So they said, yes, university is also a state and university cannot violate the fundamental rights of the students. What about ONGC? Yes, they are state. LIC, Life Insurance Corporation of India, is also state. What about International Airport Authority? Yes, they are within the definition of state. Bharat Petroleum Corporation, they are also in the definition of state. Regional engineering colleges are in the definition of state. But Board of Cricket Control in India is not a state. So dear students, these examples are telling us that definition of state is being widened indirectly by the Supreme Court. Now, what is the test? Whether a particular authority is a state or not. The test for determining whether a corporation falls within the definition of the state is whether it was an instrumentality or agency of the government. I have highlighted this portion in red color, whether it was an instrumentality or agency of the government. If yes, it was an instrumentality or agency of the government, then it is a state. And if it was not an instrumentality or agency of the government, then it is not state. What about judiciary? Judiciary as a whole, whether they are within the definition of state or not. You know the hierarchy of courts in India. starting from Civil Judge Junior Division to Civil Judge Senior Division, then additional district judges, then district judges and High Court and Supreme Court. Likewise, on criminal side, Court of Judicial Magistrate, Court of ACJM, Court of CJM, Assistant Session Judge, High Court, and finally the Supreme Court. They constitute the hierarchy of judiciary in India. So whether judiciary is included in the definition of state? Well, there are two aspects of judiciary. When judiciary is performing non-judicial functions, then they are included in the definition of word state. Like rule-making power, High Court makes rules. Allahabad High Court has also made its rules for procedure. Delhi High Court has also made rules. Supreme Court rules 2013 are in application. And you see the appointments of class 3 and class 4 employees is being done by the district judges under the supervision of respective high courts. Suppose a district judge, while making appointments of class 3 and class 4 employees, ignores the principle of reservation and does not grant any reservation to scheduled caste and scheduled tribes, then at that time district judge is acting as state. He is acting as a state, and a writ can be filed against district judge if the fundamental right of reservation of scheduled castes and scheduled tribes is being violated. But judiciary, while performing pure judicial functions, while deciding cases, they are not state. They are not in the definition of state, since there is no occasion for infringement of fundamental rights. Why? Because courts are there to protect fundamental rights, not to violate it. The exercise of judicial functions, dear students, will not occasion the infringement of fundamental rights, and therefore the question of bringing the courts within the definition of state would not arise. What a judicial decision purports to do is to decide the controversy between the parties brought before the court and nothing more. Court cannot violate your fundamental rights. Court are not bound to implement the directive principles of state policy here. It is the job of the government, it is the job of the state. So judiciary, while performing non-judicial functions, is a state. But judiciary, while performing judicial functions, while giving judgments and orders, they are not within the definition of word state. So when you file a petition under Article 32, suppose you are challenging a criminal conviction by the Supreme Court in exercise of its appellate jurisdiction under Article 136. This petition is not maintainable on the ground that judgment violates fundamental right of the accused. You cannot say in 136 SLP that the judgment of the High Court has violated fundamental right of the accused, because High Court and lower courts are not working as a state. Supreme Court also is not a state. State means Lok Sabha, Rajya Sabha headed by the President of India. Yes, of course, tribunals are included in the definition of state, and their orders can be challenged under Article 32. But Supreme Court, High Court, and the entire hierarchy of courts is not included in the definition of word state. Now, dear students, as you have seen that Article 36 defines the state, and Article 37 declares that directive principles shall not be enforceable in any court. But the principles laid down are nevertheless fundamental in the governance of the country, and it shall be the duty of the state to apply these principles in making laws. See, there are two characteristics of directive principles. They possess two characteristics. Firstly, they are not enforceable in any court. Fine. And therefore, if a directive principle is not obeyed or implemented by the state, its obedience or implementation cannot be secured through judicial proceedings. You cannot file a writ against the state that directive principles are not being followed. So this feature has been diluted in practice by court decisions, which have enforced few directive principles in support of fundamental rights. Although they are not enforceable, but courts themselves have enforced few directive principles in support of fundamental rights. Second characteristic is that these directive principles are fundamental in the governance of the country, and it shall be the duty of the state to apply these principles in making laws. The expression law here means law in a generic sense, including the power of decision making. Now let us see the relationship between directive principles and fundamental rights. You see, since directive principles are not enforceable in any court, it has been advocated that they are not law. They say that directive principles are not law, much less constitutional law, and therefore their non-observance by the state does not entail any legal consequences. For the same reason, a law giving effect to directive principles of state policy has to observe all constitutional limitations, such as fundamental rights. And in case it violates these limitations, it must be held unconstitutional. The result is 3/4. Result is that fundamental rights are given preference and directive principles are given a backseat. So fundamental rights will prevail and directive principles will not prevail. This 3/4 equation, this view was taken by the Supreme Court in an old case of reservation, State of Madras versus Champakandeo Dorai Rajan. In this case, a Madras government issued a government order which fixed certain quotas for admission to medical and engineering colleges for Harijans and other weaker communities. And this was sought to be defended under Article 46 relating to directive principles. The government said that no, for promoting directive principles, we are giving reservation to the Harijans. They pleaded 4/3. They wanted to bring directive principles on a higher pedestal. But Supreme Court held that directive principles have to conform and run as subsidiary to the chapter of fundamental rights, because they later are enforceable in a court of law, while former are not. So again, the result of the judgment is 3/4, because court has held that directive principles have to conform and run as subsidiary to the chapter of fundamental rights. So directive principles were again suppressed and fundamental right part 3rd was given preference. Next came the Minerva Mills case. In this case, you have already read and understood that Supreme Court says that harmony between fundamental rights and directive principle of state policy is an essential feature of our constitution. The result of Minerva Mill case is 3/4. Part 3rd, fundamental rights are equivalent to part 4th, directive principles of state policy. In State of Bombay versus FN Balsara, again Supreme Court held that reasonable restriction on sale and possession of liquor was in the interest of general public, which is referred as directive principle in Article 47. In this case also, the equation remained 3/4, that fundamental rights are equivalent to directive principles of state policy. This case says that there is a reasonable restriction on sale and possession of liquor. You cannot possess liquor more than a certain quantity at your home. And this restriction is in the interest of general public. And this is in compliance of directive principles of the state policy, that is the policy of prohibition. Hence, the rules which say that there shall be a reasonable restriction on the sale. A shopkeeper cannot sell in retail more than certain quantity of liquor to a private person, and similarly, private person cannot keep liquor more than 2.5 liters. The limit of keeping liquor in UP per person is 2.5 liters. So this restriction is in the interest of general public, and this restriction is in compliance of directive principle of state policy, which refers to prohibition of liquor. So the result of this case is also 3/4. If you have a fundamental right to drink alcohol, then directive principle said that there shall be reasonable restrictions on sale and possession of the liquor. Then another case is Hashmatullah versus State of MP. In this case, Supreme Court held that state cattle protection laws prohibiting slaughter of cow and calves are okay, and upheld them because they are meant to give effect to Article 48, which directs prohibition of slaughter of cows and calves and other milk cattle. In UP also we have anti-slaughter acts. All states have laws for prohibiting slaughter of cows and calves. These are again okay in view of directive principles of state policy written in Article 48. Result of this judgment is again 3 is equal to 4. Fundamental rights and directive principles are equal to each other. So dear students, by now it is very clear that the difference between fundamental rights and directive principle of state policy is that the fundamental rights are primarily aimed at assuring political freedom to the citizens by protecting them against excessive state actions, while directive principles are aimed at securing social and economic freedoms by appropriate state action. The fundamental rights are intended to foster the ideals of a political democracy and to prevent the establishment of an authoritarian rule. Dear students, it is unimaginable that any court can compel a legislature to make a law for implementation of directive principles. If court can compel parliament to make laws, then parliamentary democracy would soon be reduced to an oligarchy of judges. It is for this reason that Constitution of India says that directive principles shall not be enforceable by the courts. Shall not be enforceable by the courts, but still directive principles, they are fundamental in the governance of the country, and it is a duty of the state to apply these principles in making laws. Whenever Parliament will make law, they will keep in mind the directive principles of state policy. So dear students, this is all about today's lecture. Thank you very much. God bless you.